All right, this session is being recorded. Again, this is Mike Serra at the League of Municipalities. We'll try to keep this to an hour or less. Just some housekeeping first, if I may. This is a second briefing. If any of you attended the first, we'll be going over some familiar territory for you as well, because a number of folks, this is the first presentation. We want to make sure everyone is grounded. So I apologize if some of it is redundant for you, but we've updated the PowerPoint presentation based on questions that we have heard both in the first briefing and elsewhere. So they've been incorporated as well. This is a Zoom meeting, and we're running it as a Zoom meeting. I would ask, however, if you keep yourselves on mute for the time being during the presentation. If you have a question, we will open up at the end, so you can ask a question on camera, or you can put it in the chat box. I'll be monitoring the chat box through the presentation, and we'll throw questions to Frank and Lori. So with that, this is being recorded, so you'll be able to watch it again later. It'll be on our website. You will get a copy of the slide deck as well, which will go out to you via email. So with that, once again, I'm going to thank you all. Frank Marshall, I see you are on. Lori, are you on yet? I know you're jumping off from the clerks.
Yes, I'm here, Mike.
Okay,
yes.
Lori. So there are some questions that I'll be upfront about that we won't be able to answer yet today, because there's still guidance and there might be additional cleanup legislation coming down. So we'll identify some of those as well. We'll do our best to answer your questions. And if we can't answer them today, we'll try to get back to you with them. That's why it's good to have it in the chat box, because we'll have a record of it. So with that, I will pass the baton to Lori. I will go off camera to monitor the chat box. Again, thank you, everyone. I hope you find this presentation to be beneficial. Thank you.
Good morning, everyone. Mike, you're going to put up the PowerPoint presentation.
Bear with me one moment. It's being a little tricky today.
That way folks don't have to furiously write everything down.
All right, you should see it now.
Correct.
Okay.
So if you could go to the next slide, Mike. These are the current laws that are in effect regarding the legalization of cannabis. It's Public Law 2021, Chapter 16, which is known as the New Jersey Cannabis Regulatory Enforcement Assistance and Marketplace Modernization Act. Also Public Law 2021, Chapter 19, which regraded in decriminalization of certain future marijuana and hashish offenses. And then Public Law 2021, Chapter 25, which is referred to the cleanup bill, which addresses underage possession or consumption of marijuana, hashish, and alcohol. So when you reference back to the laws regarding legalization, you have to view all three laws together, because Chapter 25 amends sections of Chapter 16, which was amended in sections of Chapter 19. So we are waiting for the laws to become available to put one working document together to make it a little bit easier. So until that's ready, at this point in time, when reviewing the laws, please look at all three laws together. Mike, if you could go to the next slide. So your main point of contacts here at the League regarding legalization of cannabis is myself and Frank Marshall, our Associate General Counsel, who you'll hear from shortly. So here is our contact information. Mike, next slide, please. So the legislation created 6 classes of licenses for cannabis. So the first one I want to review is on the next slide, which is cannabis cultivator. A cannabis cultivator is a grower, cultivates or produces cannabis in New Jersey and sells it. And they sell and they may transport to other cannabis grower processors, wholesalers, or retailers, but they cannot sell directly to the consumer. Next slide is class 2 license, which is your cannabis manufacturer. They process cannabis items in New Jersey by purchasing or otherwise obtaining usable cannabis, manufacturing, preparing, and packaging cannabis items and selling. They have the option to transport these items to either cannabis processor, wholesalers, or retailers, but again, they cannot provide directly to the consumer. On the next slide, we'll see is the class 3 license, which is the cannabis wholesaler. They purchase or otherwise obtain, store, sells, or otherwise transfer the cannabis products, and they may transport cannabis items for the purpose of resale or to transfer to either another cannabis wholesaler or a cannabis retailer. But again, they cannot give directly to the consumer. On the next slide will be cannabis license number 4, which is a cannabis distributor. They transport cannabis items in bulk interstate from one licensed establishment to another licensed establishment. They may engage in temporary storage as necessary to carry out the transportation activities, but they're just basically the folks transporting the cannabis products from one location to another. And on the next slide, you'll see information on the Cannabis 5 license, which is the cannabis retailer. They purchase or otherwise obtain usable cannabis from cannabis cultivators and cannabis items from manufacturers or wholesalers and sells them to the consumers from a retail store. They may use a cannabis delivery service or a certified cannabis handler for the off-premise delivery of cannabis items and related supplies to the consumer. And they must accept consumer purchases be filled from its retail store that are presented by a cannabis delivery service to be delivered to the consumer. So this is your retailer. This is the licensee that's going to sell directly to the consumer. And on the next slide, you'll see on the cannabis license number 6, which is the delivery service. And there's 2 types. There's the delivery service that provides courier service for the consumers purchase of cannabis items fulfilled by the cannabis retailer and makes deliveries cannabis items and related supplies to the consumer. But for the delivery, there's also, they transport the cannabis items and related supplies to the consumer and can include a third-party technology platform to receive, process, and fulfill orders by consumer. As during COVID-19, we also the emergence of DoorDash, Grubhub. So it's the cannabis equivalent for that, where a consumer can purchase online either from their phone or at home, and then the delivery service would bring the product to their home. Next slide, please, Mike. So as a local government entity, you can enact a local cannabis tax. And that local cannabis tax has to be done by an ordinance. It cannot exceed 2% for your cannabis cultivator, your cannabis manufacturer, and or your cannabis retailer. If you have a cannabis wholesaler in your community, you can tax them at 1%. And the tax is based on the percentage of receipts on each sale. And on the next slide, you will see that you will need, the tax would be paid directly to the municipality's finance officer in a manner prescribed by the municipality. So the municipality determines how they want the tax paid to the finance officer and determines which businesses are going to tax them within their community and at what level of tax, because it can't exceed. So in theory, you can have a 1% tax on a retail. You're allowed to go up to the 2%. Though, if you have a delinquent in a local cannabis tax that's treated at the same as delinquent property taxes, the one area you cannot tax is distributors for the purpose of bulk transportation or delivery services to the consumer. So, you know, when I mentioned the Grubhub and DoorDash of cannabis, you wouldn't be able to tax them, but you could tax the retailer. We are currently working on sample language to provide for you, so that will be forthcoming. And at this point, I'm going to turn it over to Frank, who's going to discuss the license application process.
Yeah, and thanks, Lori. Mike, if you could go to the next slide here. I'm just going to cover this briefly because it's this matter is really a little bit out of municipalities' hands, but it's important that folks know who would qualify for any of these class of licenses and who the commission is going to look at, and the specifics of those individuals. So first of all, an applicant, they must have one significantly involved person who lives in New Jersey for at least 2 years at the date of the application. They must be 21 years or older. This is sort of to prevent folks coming in from out of state. They want homegrown folks running these businesses. And the commission, again, is going to adopt additional rules regarding this. So anyone who holds 5% or more of the company, or your director, any officer, and employee, they have to undergo a criminal history record background check. So Mike, if you could, the next slide, please. So for the license background check, next slide, please, Mike. Each person must submit to fingerprinting. So no check of criminal history record. When they're checking the background for the individuals, they cannot review certain offenses. Those offenses would include things such as arrests that are no longer part of the now no longer illegal under the current law because of the changes. And they have to have the written consent. I mean, like I said, I'm just going to breeze through these because there's not much municipal impact. So the applications, we'll go on to that. Next slide. So the application, and this is, I'll spend a little bit of time on this because this is going to eventually have a lot of impact on municipalities. The application, they have to require and they have to include certain things like quality control and quality assurance practices. Again, there are going to be regulations adopted by the Cannabis Control Commission that puts a little bit more meat on the bone to some of this. But essentially, the applicant is going to have to provide information and a plan for if there was a recall, and water management, waste disposal plans. Now, the municipalities can have a little bit of say in this, and we'll get into that later. But again, that this is where a lot of those quality of life ordinances and quality of life things come in, when especially with odor mitigation practices, safety and security plan, and importantly here, they have to have a community impact, social responsibility, and a research statement. So that's one of the things that we're at sort of late. And go to the next slide, please. We'll go through the process of licensing, which I'll continue here. So the license process, how it starts is first, they submit a license package with all that stuff that was included before to the Cannabis Regulatory Commission. The commission is then required to forward a copy of the application to the municipality that the licensee is or the applicant is attempting to set up shop in. They must do that within 14 days. The municipality, it's then on them to determine whether the application complies with local restrictions such as time of operation, location, manner, and as well as the municipality has set limitations on the number and types of cannabis businesses within their boundaries. So if you could, next slide. So the municipality must inform the commission, again, whether they comply with the all the issues they had before, all the ordinances, and the commission. This is important. The commission must approve the license if they meet all the requirements under the law, unless they find by clear and convincing applicant clear and convincing evidence that the applicant would be manifestly unsuitable to perform the activities for the license class sought. One of the other things, I mean, I'll make it clear here. So municipalities are allowed to determine the types and number of license classes and operations, cannabis operations and businesses within their boundaries. The commission also is going to set a cap on the number, but it's important to remember that municipalities can also go within their specific caps themselves. But there would be a statewide cap as well on the number. So next slide, please. So again, as I mentioned before, some of the things the commission can't consider: conviction of a crime or offense involving controlled dangerous substance that is now legal under the current laws, you know, through this bill and then through the other bills. But some of the things they can consider are convictions involving fraud, deceit, embezzlement, employing a minor in a drug distribution scheme, and other similar offenses. And so next slide, which we'll get into the Cannabis Regulatory Commission, and with that, I'll let Lori take back over.
Thank you, Frank. So the Cannabis Regulatory Commission, not to be confused with the Casino Regulatory Commission, has 5 members on their board. Diane Waynow is the commissioner's chair. Krista Nash, Maria DeSille, William Wallace, and Sam Delgado are the members of the commission. And that commission is going to determine the date in which retailers can begin retail sales. They also have 180 days from the law being signed, so that's August 22nd, to adopt rules and regulations. And Mike, if you can go to the next slide, we'll review the type of rules and regulations that the Cannabis Regulatory Commission will be considering. So they will have to adopt rules governing license eligibility, application, and evaluation, the number of permissible license of each type. And I just want to be clear on this point. So the Cannabis Regulatory Commission has the authority to determine the number of permissible license of each type, but each municipality has the authority to determine what types of cannabis businesses and how many cannabis businesses they would like in their community. So there's 2 different levels to sort of keep in mind there. But the Cannabis Regulatory Commission is also going to have to adopt regulations on security requirements for all licensees, labeling and packaging requirements, cannabis retailer employee eligibility requirements, advertising and marketing limitations are some of the areas they're going to address. So right now, the commission has been, all members of the commission have been appointed and they have begun their work. They do have a very short time frame in which to adopt these rules. And as more information comes out from the Cannabis Regulatory Commission, we will continue to keep you apprised. And with that, the next slide, I'm going to turn it over to Frank, who's going to discuss the municipal regulations and ordinances.
Thanks, Lori. So the municipalities have a little bit of leeway here. They can govern with any business. The best way to think about this is with liquor license. So you can govern the times and operation, location, manner, number, and type of cannabis businesses, and establish civil penalties for these ordinance violations. One other important aspect here that we should address is that there are retailers are allowed to request a permission for a consumption area. So how that works is the retailer must get the approval and endorsement from the municipality before they can do any consumption area. So that can be an indoor or outdoor consumption area. There are limitations set in place, obviously, within the law about what these areas look like. For instance, they have to be separated, they have to have proper ventilation, odor mitigation. That's within the law itself. But again, no retail license facility can have that without the municipal endorsement. So that's not something that can sort of be forced upon anyone. So one of the other things, though, is that you cannot prohibit cannabis delivery services. That's those Class 6 licensees. You cannot prohibit them from delivering within your municipality. One of the things you can do is you can sort of prohibit them from having a base of operations, but you cannot prohibit them from coming in, crossing municipal borders, and delivering to folks that have ordered. Say even if your town is completely banned all licensees from operating, you cannot ban the Class 6 delivery folks from coming in and delivering. And what the bill has done now, it's voided any other previous cannabis ordinances you've had. So that means even if last year or 2 years ago when this was first starting, if your municipality had set up some sort of regulation for recreational cannabis or had outright banned it, that's voided. You're going to have to take action to re-adopt it, or if you're reconsidering what you're doing, what you want to allow in your municipality, you would have to start fresh and start again. So next slide, please, Mike. Yeah, again, another little bit, I forgot we've added this, the cannabis consumption areas. So this, again, can be for a retailer or a medical dispensary. You can have the on-premise consumption where personal use may occur. Again, there are some, you'd have to apply to the Cannabis Control Commission for this, but you can only apply once you have the municipal endorsement. So for the indoor facilities, they have to be structurally enclosed and separate from the dispensing area. And outdoor, it has to be sort of connected to the same property. Now, one of the things, clearly on there, they can transfer the cannabis items from the establishment to the consumption area. Go ahead, Mike. Next slide, please. Oh, I think you went back.
You went backwards, Mike.
One more. Forward. All right. So there is some limitation on the sale and where these retail licensees can operate. So you cannot operate or have for sale cannabis in grocery stores, delis, indoor food markets, or other stores engaging in retail food sales, as well as any premises licensed for retail sales of alcoholic beverages. So one of the questions that we got in, I'm not sure if it was during another presentation or just elsewise, was about farm markets. So right now there is no indication that you would be permitted to sell marijuana or cannabis or any products at any outdoor farm markets, because again, the license has it's a licensed premise. So there's no sort of, there isn't that, if you can liken it to the alcohol license, the liquor license, there isn't that separate license where you can go off premises. In the future, who knows if that's going to change? I don't think it's going to happen anytime soon, but for these purposes right now, it's only in the facilities and in that structure that has been designated by the licensee. So next question, or sorry, next slide. The opt-out ordinance. Again, this is something that I want to be clear on, so I'm going to take my time. What the law has done is it's created an opt-out. So that means that by default, everyone is opted in unless you take action within 180 days to opt out. And you can opt out from a specific type of license, all license, or any number or any sort of combination you could, any class of license. Again, that's 180 days from February 22nd. One of the things you might be hearing from us, I know we put out some of this guidance along with New Jersey Institute of Local Government Attorneys. If you're unsure or if you need more time to address it, you should think about opting out entirely while you take the time to address it. and create a plan, because failure to opt out within that 180 days results in class 1 through 4 licensees and class 6 becoming a permitted use in all industrial zones. And it also would create the retail sale, which is class 5, a conditional use in all commercial zones and retail zones. So there is a little bit of a you become sort of locked in. And what happens if you fail to opt out is that within that 180-day period, if you fail to opt out, you cannot opt out again for 5 years. So if you opt in, it's the same thing. Or I'm sorry, if you create an ordinance, opting out or opting in, you have to wait 5 years. And let me just rephrase that because I know that's unclear. If you opt out, you can opt back in at any time. But if you opt in, you are locked in for a period of 5 years, no matter what license you have there. If, say, for instance, you allow class 1 and 2 licensees, but you have opted out of class 3 and 4, you can opt in anytime with 3 and 4, but you cannot opt out of the class 1 and 2, which you had opted in for a period of 5 years. Now, after that 5 years, there's another 180-day period which you must act, or else you're locked in for another period of 5 years. So just to make that clear to folks, it's probably still clear as mud, but if there are any specific questions, I can answer it. So next slide, please, Mike, if you would.
Frank, real quick,
Sure.
while Frank, Mike's moving to the next slide. You can opt in, for example, this year for retail and opt out the other classes, and then next year opt in for another class, so that 180 days can be different depending upon when you opt in for the different licenses, correct?
Yeah, that's correct. And I should mention again, and I think I just saw the question pop up in the chat here. So if you've opted in and someone becomes licensed in and sets up shop in a municipality, but then try to opt out, that licensee and that operation is grandfathered in. So if you were to opt out after that 5-year period, it's only prospective. It wouldn't apply to anyone who's already operating and already in business. So that's why it's important that folks sort of have a real good idea of where they want to be. And so now we'll move on to a little bit of a nuance here within the bill, and that's micro businesses. So micro businesses have sort of a little bit of, they're still licensed as a class 1, class 2, or anything like that, but they get a little bit special treatment, so to speak, when it comes to the statewide cap on the number of businesses that are licenses that are going to be issued. So the micro business, it's a person or entity that's licensed as a grower, processor, wholesaler, distributor, retailer, delivery service. They have no more than 10 employees. They have to operate in a space of no more than 2,500 square foot, and with a small exception for growers. And they're not allowed to process. They're not allowed to process no more than 1,000 cannabis plants each month. The cannabis cultivator cannot acquire and process more than 1,000 pounds of cannabis in dried form each month, and a cannabis wholesaler cannot acquire for resale more than 1,000 pounds each month, and a cannabis retailer cannot acquire 1,000 pounds each month. So again, these are sort of a little niche within the law to sort of provide a little bit of difference for maybe downtowns or these non-conglomerate, so to speak, as we've seen across the country. You've got these huge operations that are sort of taking over, not necessarily taking over, but it's really just a larger company that owns a bunch of different things. So next slide, please. The next sort of little nuance here is the impact zone. So this can be any municipality, and you're considered an impact zone if based on past criminal marijuana enterprises contributing I'm sorry here. So the impact zones are really for those areas that had a high concentration of law enforcement activity, unemployment, and poverty, and had a lot of, where the marijuana sales were going on before it was legalized. You have to have a population of 120,000 or more, based on data from the calendar year 2019. You rank in the top 40% of municipalities with marijuana or hashish related arrests. A crime index of 825 or higher on the annual Uniform Crime Report. And you have an unemployment rate in the top 15% of all municipalities for the calendar year next preceding the effective date of the act. Or if you're located within a county or third class, this is a little different here. If you don't qualify for any of the other things, but you're in a county of the third class, and you meet all the criteria except that 825 or higher crime index. Or if you're located in a county in the second class, based population data, the most recent census, and meets the other crime and population standards. So this is a little bit, like I said, it's funky. It's not necessarily something I'm terribly familiar with, but again, it adds a little bit of nuance, and it really strikes at the social justice aspects of the bill and trying to right past wrongs. So next slide, please. Okay, so this actually is dealing with the with the cleaned up language and some of the other bill, the decriminalization aspect of the new cannabis laws. So what the law did is it repeals the statute to NJSA 40:48-1.2. And with this repeal, it effectively prohibits municipalities from adopting an ordinance that prohibits underage consumption of alcohol and cannabis on private property. So this has probably been, this has been a huge issue, and you're going to hear a lot of talk about it. So Mike, if you could, next slide, please. Yeah, again, this is the decriminalization aspect here. So what they changed, and there's a little bit of nuance because there's the underage possession or consumption of cannabis and alcohol, and they were sort of lumped in together. But then there's the minor possession and consumption. So underage are those folks in that range between 18 and 21, or really anyone under 21. And then minor is someone who's obviously under 18. So what's happened here is that alcoholic beverage, marijuana, hashish, and cannabis items, if you're caught underage in the possession, your first violation, you get a written warning. And as the law currently is, it's a written warning, and the police are not allowed to notify a parent or guardian. There's current legislation that's been put forth and had a committee hearing yesterday, which is A5427/S3545, that would allow parent and guardian notification. So the second violation, if you're caught underage possession or consumption, you get a written warning, and the police must provide you with information and materials on social services to the offender. And if the offender is under 18, notice is provided to the parent or guardian. And for the third or subsequent violations, you get a write-up. That's how it's termed. Not necessarily sure what that looks like. It's not a ticket, I don't want to say, or anything like that, or a citation. But you get a write-up, and you get information and materials on social services that must be provided to the offender. And the write-up comes with a referral to the social service organizations, and those organizations are then allowed to reach out to the individual or parent directly. So next slide, please. So underage possession or consumption. So one of the other changes is for the decriminalization aspect is how the police can interact with folks that they suspect or come in contact with to be, not of the legal age to possess or consume cannabis or even alcohol. So one of the things that changed is that they clarified that individuals under the legal age are not capable of giving lawful consent to search to determine possession or consumption violation. Police are not even permitted to request a consent to search. In fact, if they do, they're subject to certain penalties for civil rights violations. And the odor of marijuana no longer constitutes reasonable articulable suspicion to initiate an investigatory stop. And there's no probable cause to initiate search of a person or their personal property. So this has been a big change, obviously, with how policing works. And also, again, because cannabis is legal, cannabis in plain sight no longer constitutes probable cause to initiate a search of a person or their personal property. A lot of this guidance and a lot of these questions, the Attorney General's office has put out some FAQs and has put out some guidance to law enforcement across the state with some pretty helpful resources. And I know they're probably continuing to update these as they come along, and we'll be sure to share those. And I think we have that a link to the Attorney General's page on our website, on our cannabis page. And Mike, if you could go to the next slide. Oh, and these are the resource page. I'll let Lori go through these if she would.
So on, and this presentation is going to be emailed to everyone that's participating on this call today, but we included a league sample opt-out ordinance. We included the Attorney General marijuana decriminalization legalization resource page. We had a cannabis in the workplace seminar on March 9th. I apologize, that should have been removed. And we do have upcoming cannabis workshop on the municipal land use law on cannabis. We also have a cannabis resource page that we're frequently updating with information. And based upon our last presentation in this one, we're going to be creating a frequently asked question page that will be updated frequently as well. So just come back frequently to that NJLM cannabis page for resources. And if you can't find the answer there, Frank and I are always available to take a call or email us a question. We'll get back to you. And with that, Mike, I think we're ready for the next slide, which is the questions. So
Yes, hi. Sorry. Well, first I'm going to throw one out, and I'm also going to go to the next slide for everyone. And again, you'll get the slide deck, but I just want to provide everyone with contact information for our legislative team here at the league as well. For obviously for questions on this issue, direct to Frank and Lori. On other issues, we're providing you with that contact information for you. And just a couple of comments. If there is a date to circle on your calendar, I guess it's August 21st, Frank. The 180 days. I believe day 180 is actually on a weekend. So you might want to do it by that Friday at the latest if you're gonna burn the midnight hour on that one. But obviously that date in August is critical to act in terms of your ordinances. I'm going to turn the screen share off in a minute, but Frank, as I mentioned to you before, and I'd like it to be addressed, I gave a presentation similar to this last night, and the question regarding banking and it being an all cash business came up. So as I turn off the screen share and Lori and I work through the chat box, could you address that issue of the all cash businesses?
Yes. So Mike's right. Right now, one of the big issues facing the industry is that marijuana and cannabis obviously is still a class 1 drug and it's still illegal at the federal level. And what happens is, although states are legalizing it, the federal government has not. And the federal government are the ones that regulate the banking industry. And so a lot of banks are hesitant to take in any cash. I mean, so what happens here is that you need a bank, and you need the banks are the ones who do the credit card transactions and everything like that. So the marijuana and the legal cannabis, those retailers can't accept credit cards. So you have to do everything essentially through a cash business. One of the other aspects is that the banks won't necessarily, or again, there are some, but not a lot, that are friendly and will accept the cash deposits, even knowing that it's coming from illegal sources, so to speak. Illegal in the sense that it's illegal at the federal level. So this puts retailers in a little bit of a predicament because they can have at times a lot of cash on hand, especially if they aren't lucky enough to work with one of these banks that will accept the cash. Credit unions are a little bit more friendly to the business simply because they operate under a different structure, different regulations. But this is a concern, and this is a huge security concern because it leaves the retailers open to theft, fraud, and a lot of other things. I know the state has looked into creating a state bank, which would again put it outside of the regulations of the federal government. And I know there are some efforts at the federal government to, relax some of the restrictions so that, obviously they see the momentum towards legalization. So there are some bills out there at the federal level that would open up and allow the industry to just essentially allow them access to banking. So that's and Mike, do you have any other specific questions on that, or just wanted to?
It was more of a general question, Frank. Just because of and there might be legislation moving in DC that might address this as well eventually, but just kind of where things stood in as these operations come online in the upcoming months.
Yeah, and I should mention that one of the things that the banks that do accept the cash deposits, lots of times what they do is they can submit what's known as sort of like a possible fraudulent or illegal. I forget how the term is, what they term it as, but essentially they're covering their own butts by saying, hey, we've got this cash, we think it may be something illegal, and then they just file that with the regulatory board, and that covers them. And so far there hasn't been much in the way of enforcement, but again, there's always the risk, given a wind change at the federal level, that there could be some enforcement or anything like that would cause the banks to lose or get in trouble. But fortunately, nothing like that has happened.
All right, and I'm looking in the chat box. I think some of these questions were answered during the presentation, but we can highlight them. One other point, just to dovetail something that Frank had said, and that is a lot of this is still evolving. And it mentioned, yes, regarding decriminalization, there was a bill that came out of committee yesterday dealing with the law enforcement issues in decriminalization. So this is, we've already had one cleanup bill. It looked like there's going to be another cleanup bill. There might be multiple cleanup bills over the course of the next several months or year. So that this is an evolving process. The first question I see is, is whether you can exclude certain types of retailers, meaning only pharmacy allowed, not recreational. I think that falls into a medical license for prescription. So Frank and Lori, correct me if I'm wrong, I believe you can host a medical dispensary, but ban retail. But I guess there might be one issue about vertical integration, or whether or not the medical facility, the conditions to seek a retail license.
Yeah, you're right, Mike. You can exclude, you can permit medical license facilities while excluding the recreational retailers. So if your town has these, the medical facilities, you can certainly separate the two. Again, there is the question about the when it comes to converting or creating a hybrid facility. But again, in order to do that, to get that class of license, you need municipal consent. So you could certainly limit it between medical and recreational.
All right, and we have about 15 minutes, so we'll try to run through these as we can, best we can. I know Mayor Gail Brill Mittler was on. She may have, she sent me that she may have left, but she was asking about what category does a cannabis lab testing facility fall under? I don't know if that's addressed.
Yeah, so that's not addressed. I mean, it's going to be addressed obviously in the regulations that come out, but so each facility is sort of responsible for their own testing. So I would imagine if they're doing it in-house or if they're sending it to a separate facility, I mean, these facilities obviously already exist for medical purposes. So there's probably a way that they would function and sort of fit right into something that's already in place.
All right. And again, if you want to ask your question verbally, there's a raise your hand feature as well. But we'll continue to work through the chat box. What about Andrea is asking about a entity holding multiple licenses. I guess this is the concept that we know is vertical integration. Can one of you address that?
Yeah, so anyone's obviously, if they apply for the type of license, is able to, if they apply and they're accepted, able to have a vertically integrated business. So I'm not necessarily, I think the question was probably asking about something specific during the presentation, and I apologize if we missed it, but again, municipalities can, you can restrict if someone's going to be a vertically integrated business simply by prohibiting one license or another, because you're able to do that. It's not a all or nothing sort of thing. You can have class 1, 2, 3, 4, or 5. But if, obviously if you take out the municipality prohibits a class of license, then that business can't have that vertical integration.
And if I may just add to that, Frank, if you're the Cannabis Regulatory Commission has sort of parameters of how many issues they can license, to whom they can be issued to, and how many they can be issued to. So if it's the concern of, for example, ShopRite holding multiple liquor license, if that's the concern, the Cannabis Regulatory Commission sort of has in the legislation parameters around that, and we can give you more specifics about that if you just shoot us an email.
All right, the next question was on, it might be a very specific question. If there's unused public property or land in a municipality, can that municipality authorize via ordinance that land be used for cultivation or other cannabis activity, and the public entity enter into a lease with a private entity via some form of competitive process? So I guess this is publicly owned land, and whether it could be leased to a cannabis licensee, the question as I understand it. I don't know if that's addressed in the bill at all. That might be a regulatory issue.
It's certainly an interesting question, one that I haven't heard before. So I don't know if it's specific.
L London, we're going to bring that one to the Cannabis Regulatory Commissioner. That's a good one. Can we charge a local permit fee?
You can enact the local cannabis tax, and I don't know if that's with the references to permit, or if you want an application fee similar to what you do for liquor license, that will be a regulatory issue, but you can do a local cannabis tax.
The slides will be emailed to everyone after the presentation, and the video and a link to this video as well. in response to Patty's comment. Let's see. Lafayette would appreciate a copy of the template. Kevin O'Leary, we'll follow up with you specifically on that one. Will the commission be issuing retail licenses by August 21st date or after?
It would most likely be after, because the Cannabis Regulatory Commission first has to draft the rules and regulations, and then they determine at what date the retail sales can begin. So once they get the regulatory process completed, we'll have more information when they will start issuing the licenses.
Right, and let me interject here too, based on another question I got on my presentation from last night. Kind of harking back to the movie Field of Dreams. If you build it, they will come. You can only create the opportunity for a licensee to come in the community if you want to host one of the types of licenses. So you can zone to opt-in retail or cultivation, but ultimately they have to get licensed by the state. So you create the opportunity for that business to operate in your community if you want it, but they ultimately the state almost has the final say because they issue that license. So I just want to be clear on that based on last night's presentation. Let's see, the next question. I'm trying to move through these quickly as we can. How does time to improve applications square with timeline for planning board or zoning board adjustment hearing process? I'm not sure I quite understand the question. Chuck, are you still on? I see you right there. Can you I'm sorry. I apologize. I don't know if I quite understand it.
Yeah, I was just wondering if the retail use becomes a conditional use in all, the retailer license 5 becomes permitted in all commercial zones as a conditional use, or even the others which are permitted as of right in these other industrial zones, they still would have to go through local zoning board or planning board approval process, I would assume. So
Correct.
If there's a timeline, the slide went quickly, so I wasn't able to catch it, but it seemed like the municipality has a limited period of time to approve an application. And if I misunderstood that, you'll clarify, but the application would be contingent upon going through the approval process, would it not?
Yeah, so part of the application process to the state is that they have all of the requisite permits and everything in place from the municipality, including that municipal endorsement or anything that could happen, and then including any planning board applications being reviewed or anything like that. So, so they would still obviously have to, again, when you mentioned about the conditional use, they still have to go through the planning board and the land use board, all of those requirements that anyone else typically would.
Thank you.
All right, thank you, Chuck. The next question, I think I just answered it. How does a statewide cap on total licenses work with respect to the number of licenses that a municipality may issue? You don't. The municipality doesn't issue the license. Again, you create the opportunity for a licensee to be hosted in your community, but the licensing process itself is through the Cannabis Regulatory Commission. So I think I answered that one. The date is the same date municipalities have to act, so we have to act before they've given us information. Possibly. I mean, the casino, I'm sorry, I knew I would do it. The Cannabis Regulatory Commission, I'm showing my age by referring to the Casino Regulatory Commission. The Cannabis Regulatory Commission hasn't even met yet. And I would anticipate they're going to do emergency regulations, but even an expedited regulatory process at the state level is going to move slower than at the local, than you act at the local level. So yes, you might not have all the necessary information to make that, to make your the determination. So, which is, I think, where, the Institute for Local Government Attorneys and of others have said you always have to fall back to opt out, because you could opt in at another time at a point that you feel more comfortable. Moving on, does the municipality have to pass an ordinance that would include the delinquent rate applicable to the property tax applies to overdue excise tax applicable to sales? Well, that's above my pay grade, Lori.
It probably does. We're still working through that, but you do, just as you do in your administrative code, have to lay out your delinquent property taxes. You would have to do similar for your local cannabis tax. So yes.
The next one is an interesting one. Can you regulate Class 6 delivery areas such as not within X feet of a school? Well, you can't exclude Class 6 delivery.
Correct.
I would have think that, that's a very good question. I think that going to have to be addressed by the Cannabis Regulatory Commission, since they will be licensing and regulating the Class 6 licensees.
And Mike, that leads to a point too. There is still more that we need to learn about the impact on the drug-free school zones or near the houses of worship and such, that the Cannabis Regulatory Commission needs to work through as well.
Is cannabis allowed to be smoked in public? That kind of dovetails what we just talked about.
Yeah, so this question I've looked into a little bit before. So the bill already prohibits, there's obviously the Clean Air Act, which prohibits smoking and in certain locations, smoking in any form, with tobacco or cannabis. But then cannabis consumption is already precluded or prohibited where alcohol consumption would be prohibited in public space. So there's sort of, there's that nexus between the two that should be followed.
Let's see. Similar, do we have to pass new ordinances for the parks that are smoke-free or for cigarettes? Kind of dovetail what you just said, I believe, Frank, right?
Yeah.
The next question is, so no mobile sales, similar to a food truck. I think the only mobility that's addressed by the legislation is the delivery component. I don't think anyone's envisioned mobile sales or transient sales or, the cannabis truck going through the neighborhood. So I don't think that's contemplated it's not contemplated in the legislation. And I don't think it's going to be contemplated by the Regulatory Commission. All right,
again, the license is for that, part of the license is for that facility, part. So there wouldn't necessarily be, at this time, there's no mobile sales or anything like that allowed. I think the question came up when I was talking about farm market, sales at farmers markets and things like that.
Okay. Did you say stores that sell liquor will not be able to sell cannabis? Well, they're separate licenses.
But they wouldn't be able to. It's one of the areas that you can limit the sales.
If you opt out and revisit in 5 years to opt in, what happens to the businesses that have set up a retail store? I think you, Joanne,
I answered that.
I think you need, if you opt in and then you opt out.
Yes, I think that question was answered already.
Okay. Okay.
Anybody who, has that 5-year period to have a license in the town, they're grandfathered in if after 5 years they decide they don't want to have that anymore.
The terminology isn't exact, but it would be, Frank, essentially a pre-existing non-conforming use.
Yeah, exactly. You're grandfathered in. Any opt-out that you do after after you're in is prospective only. It doesn't apply to anything else, and you're just, again, like you said, it's likened to a pre-existing non-conforming use.
David, does each license have an individual 180-day opt-out or opt-in provision? The 180 days is on the municipality to opt in or opt out by ordinance. So the licensee, their application, I mean, they have to make obviously separate applications in terms of the locating in the host community and to the state, but the 180 days doesn't apply to the licensee. Do micro businesses require the same license, home-based? But definitely not home-based. And micro businesses would be licensed as well by the state. Right. Frank, Laurie, am I missing something or?
Yes. So again, the micro businesses are just, they're exempt from some of the statewide caps on the number of licenses. But you know, obviously there is no home base, there's no home grow allow. I mean, there's some talk of it, but right now this bill didn't address it. There is no home grow at all allowed.
All right, we're at the 1 o'clock, so we may start losing people. We'll try to take a couple more questions, and the rest will. We are preparing an FAQ, and we'll have the FAQ for everyone. Let's see if there's any that we can answer real quick. Home cultivation is not allowed. Lori, if you can help me, are there any questions in here that we haven't addressed in the presentation? Or Frank? I want to be respectful of people's time.
Through.
As I'm searching through these, I think most of them have been asked or were answered in the presentation. But again, we'll be compiling these questions. I do see what addresses the THC level that is permitted. That again, that's going to be the determination of the Cannabis Regulatory Commission. The licenses, I believe, are set by statute, but might be expanded at some point. Maybe we'll wrap up on this one because it's of a particular local interest. Do all regulations have to be approved by the land use board? So, Frank, can you address specifically what the applicant has to do at the local level? I think that might be what a lot of folks might be interested in.
So the applicant obviously has to comply with any ordinances that the municipality has put in place to time, manner, time and place restrictions. Hold on, I just lost the question here too. When it comes to the land use board, I mean, you could set up your license any way that you want. I mean, let me clarify. So the regulation doesn't necessarily, at the municipal level, doesn't necessarily have to be done through a zoning or land use ordinance, because the law, the way it's set up, has a specific authority for municipalities to allow a certain class of license. It doesn't have to be done through zoning. You can simply say, that there's no class 1, class 2, or anything like that, and they just simply can't abide. Now, if you're going the zoning route, which just makes sense because a lot of times you want to say, okay, we'll allow class 1, but they can only operate within this certain zone or certain area. And for one of the other questions we've gotten before is about parking spaces and lighting requirements. You're certainly free to do those, set those requirements like you would any other business or facility. So just the same as that facility would have to go through the same land use approvals, board approvals. You could subject these businesses to them as well. So again, excuse me, there's multiple ways you could do it, but a lot of folks connect it with zoning and land use simply because they want to limit to the areas that the businesses could be allowed. But again, you can create it, regulations outside of that if you so chose.
All right, Frank, there was one question very quickly if we can. And this may require some follow-up, but it's a good one about redevelopment areas. How are redevelopment areas affected since they do not typically have conditional uses? I think that was one we may need to get into because there is some specific language about tax abatements and tax exemptions. So I think that's one. It looks like Alonso. Maybe we need to. We'll circle back with you specifically on that one.
Yeah.
All right. Well, again, we're at 1:07, so we've gone a couple minutes over. So I apologize for that. But I want to thank everyone for joining us. I hope you found it helpful and beneficial. It is being recorded and it will be made available on our website along with the slide deck, which you will, if you registered through our website, you will get that information mailed to you. If it was forwarded to you or sent separately, you might not be on the list. So just email us and ask for it if you haven't gotten it, say by this time tomorrow. Thank you again. Well, this is going to be part of a regular series, so I hope you helpful and hope to see you all again. And I'll do a commercial at the end. I hope to see you all in person in Atlantic City in November. We expect to be there. So thank you and have a great day, folks.